Being here and talking for the purposes of the CEU mission reminds me of the old days when I was studying there and when I was getting assignments from my legal department on a regular basis. However, this today is quite different. And I'm going to talk about the issue of referendum in Croatia because I think that this is quite an actual topic these days and it has been for the past few years in Croatia. In these 15 minutes I will try to briefly just highlight some most important things related to the issue of referendum and its position in the constitutional scheme of the Republic of Croatia. Let me start, as many lawyers, with the textual or constitutional basis for the institute of referendum in our constitutional system, which is mainly here in Article 87 of our constitution. Now, I will try to go through all of these paragraphs in the following slides, but for the beginning, let me just say that, as you can see, some parts of the sentences here are highlighted in red, that almost all of the provision here has some typical significance and provokes some typical problems related to its interpretation. First part of the problem is that the referendum in Croatia may be called upon for many things, including classical examples of the amendment of the constitution or enacting a bill or a law. However, there is one very significant problem with our constitutional provision on a referendum, and this is the one which provides that, among other things, referendum may be called in the event of regulating any other issue within the competence of the parliamentary body, Croatian Sabor. As you may guess instantly, this is a quite problematic provision because it is vague, it is broad, it's not focused, it has to be interpreted in practice. If you go logically, you will see, systematically reading the constitution, you will see that the Croatian parliament, as many parliaments in the world usually do, the Croatian parliament has competence to regulate many things. This raises separate questions. Is it possible, therefore, to say that the referendum may be called in the case when deciding on issues such as declaration of war, because that is what the parliament does, vote in confidence for the government, that is also a typical prerogative of the parliament, state borders, when the state has to change its borders or has to decide on where to draw the border, the parliament regularly gives a consent. Human rights. There is a whole array of human rights in Chapter 3 of our Constitution dedicated to specific civil, political, economic, cultural, social and other rights. Are these also the questions that may be decided on a referendum? According to the provision that we have in Article 87, that is so. And the state budget, for instance, inevitably, a conclusion must be that there has to be some type of interpretation given by whom? Typically by a body which performs some kind of controlling function in the constitutional system, that is a constitutional court. Depending on that, we will have a case law in the future which will have to clarify these questions. However, I must say that if you follow the case law from the recent months, you will see, especially the cases from this year, you will see that the Constitutional Court in Croatia already started to recognize that there are some questions that are exempt from the regulation of a referendum as it is presented in the textual interpretation of Article 87 of our Constitution. What is my intent here is to just highlight again that there are some typical textual problems which might appear as very big practical, political, social and constitutional problems in the future if they are not properly interpreted. The second part of the problem already dealt by the Constitutional Court in Croatia is a typical institute of a so-called citizens or popular initiative. Croatian constitution adopts an approach according to which from 2000 revision of the constitution that a referendum may be initiated among other actors also by the electorate itself. In our case, that means that 10% of voters, Croatian citizens who have a right to vote may, through collection of their signatures, initiate such a referendum. However, the wording again, constitutional interpretation, textual interpretation of our constitution creates problems because when properly translated into English, this part of the provision says that the referendum in this case may be initiated if there is a 10% of the total electorate in the Republic of Croatia. What does it mean practically in the Republic of Croatia? 10% of voters in the Republic of Croatia. Does that mean that only voters who are territorially in Croatia count? That's actually what the Constitutional Court said. Or we have somehow to include other citizens who also have voting rights, but who do not, at the relevant time, reside in Croatia. As you probably know, we have quite big diaspora, citizens of Croatia living abroad. If such approach is adopted, then we have a very interesting problem, because if we follow textual interpretation of textual wording provision as such in the Constitution, we inevitably divide our citizens into two categories, according to which one category counts against 10% request in the Article 87, and other category, in other words, diaspora, does not count. There is also another problem with the constitutional provision on a referendum in Croatia. Moreover, in 2010, there was one very significant amendment package to our constitution, mainly motivated by our approach to the European Union. Among other things, part dedicated to the referendum in the constitution was also amended in a way as to prescribe, and that is the situation also now, that the referendum will be valid if the majority of the voters who participated in referendum voted for some decision, not out of the whole population, not out of the whole number of the electorate or the citizens, but only out of those who took part in referendum procedure, practical referendum which has been organized for some event. It was a solution that was severely criticized by opponents, mainly opponents to the accession of Croatia to the European Union, for the lack of legitimacy of the whole procedure and so on, as you might guess. This is the most known part of the story. However, I have to emphasize that there was at that time, and still the same problem exists today, one particular problem related to the unsettled list of voters in Croatia. Because at that time, actually it is hard to believe, but it was the case that the state administration did not have proper knowledge on the right amount or the right number of actual voters in the Croatian electorate in general. So in order to avoid abuses, because the voters lists were not regularly settled, in order to avoid abuses, it was said that this solution was, as a practical matter, better than the solution, previous one, which included all the voters who at least nominally had the right to vote. So the solution was practical, and from that point of view, quite, I would say, defendable. The role of the Parliament. There was a dispute between the Constitutional Court and the Parliament related to the issue of the referendum on marriage in 2013, when one citizen initiative successfully collected 10% of the signatures and initiated and eventually organized a referendum on the definition of marriage. However, in the early stage of the whole procedure, the Parliament tried to treat the whole process just as the beginning of a more broad constitutional process of amendment in general. So the Parliament tried to treat the initiative just as a first step of a procedure which has to be eventually finished by the Parliament itself. So the Parliament, in other words, tried to evade the will of the people on that particular referendum. However, the Constitutional Court stepped in with its warning and said that this was not possible according to our Constitution. There are actually two ways of amending the Constitution. One, typical procedure in the Parliament itself, and another one with the direct effect, a referendum. So once the referendum was properly called and organized and held, the effects of that referendum were immediately recognized in the legal system. This was the first part of a huge battle between the Constitutional Court, I would say, and the Croatian Parliament. Ended with the victory of the Constitutional Court, and afterwards, if you follow the case law of a referendum in the following months, up to this day, you will see that the Croatian Parliament did not follow the same approach and policy, and really acknowledged that it's powerless in terms of popular initiative, which has properly collected 10% of the votes in Croatia. There is one very, I would say, collateral, but still an important problem with the fact that after the 2010 amendments to the Croatian Constitution, it was provided that further legislation on referendum will be enacted in the Croatian Parliament. However, up to this day, and this is more than 5 years, the new law on referendum has not been enacted, and this is the problem also, because we have some contradiction in what the Constitution now says about the referendum and what the actual law on referendum says in terms of majority. Nevertheless, this is a problem because it shows, it reveals a reluctance of the Parliament to really properly follow its constitutional obligation imposed on it by the constitution maker itself. The Croatian Constitutional Court warned about this fact and said that this should not be taken out of the picture and that the new law should be enacted. However, the will of the Parliament, political will in the Parliament, did not obey up to this day. We'll see what will happen in the next following months. As you might know, at this time there is a specific bill on new referendum law in the Croatian Parliament. However, our elections are approaching, and there is some basis to think that disputes between political parties will furthermore extend the whole discussion for the end of this year or maybe beginning of the next year. As one of the first, and this is not the complete list of all the case law related to referendum in Croatia, one of the first examples was the referendum on the Labor Act, which was organized a couple of years ago, and which is interesting because the whole story was linked to the problem that at that time the economic crisis already started in Croatia, and the government, tried to enact the labor law shortly to restrict some social rights. Trade unions, of course, resisted, opposed, organized the referendum, and tried to prevent enaction of that law. Technically, the government withdrew its bill from the parliamentary procedure, and then the Constitutional Court stepped in with its own interpretation and said that once the law has been withdrawn from the parliamentary procedure, there is no need for a referendum anymore. So the whole referendum actually failed on that basis. However, this was also an occasion for judicial activism of the Constitutional Court, because the Constitutional Court there said that despite the fact that the bill was withdrawn and there is no need for that exact referendum, if the government, the Constitutional Court said, if the government tries to impose the new same bill in the following 1 year, then it has also the obligation to organize a referendum following the fact that already 10% of the votes have been collected. This is a typical story of judicial activism, because such a term of 1 year has not been prescribed anywhere in our constitution or in our law on referendum. However, the most notable example of referendum in Croatia was the referendum on the constitutional definition of marriage from December 1st, 2013, which is interesting. I have already mentioned it, but this time it is also interesting because it is a typical example of both the judicial activism and judicial self-restraint in terms of the practice or the case law of the Croatian Constitutional Court. Why judicial self-restraint? Because the Constitutional Court formally did not have a power to rule on the constitutionality of the referendum. That's very much true. But the Constitutional Court did offer some analysis, which mainly consisted on the analysis of the comparative law of the European countries. And there the Constitutional Court said that in Europe there are three categories of countries which differently define marital and related types of relations. Those who prohibit same-sex marriages, those who allow explicitly for it, and those who allow for both of these positions. And Croatia, obviously belonging to the third category, the Constitutional Court, that there is no real dispute in the instant case here, so it allowed for the referendum. But furthermore, the Constitutional Court did not go into details and did not actually apply what is its typical tool in resolving constitutional disputes related to human rights or fundamental rights and freedoms. In other words, it did not balance against certain categories of population and new scheme of definition of marriage as it was proposed and imposed in the constitutional system. Therefore, the Constitutional Court was really self-restrained. However, what is, I believe, deeply believe, a fact that was not properly observed in public, in the same case the Constitutional Court also showed the most striking example of judicial activism, because it said in the opening and closing part of its decision that apart from the actual case, the Constitutional Court also has a power to rule on the constitutionality of any referendum if it wishes so, and that it has a power also to actually imply what is in constitutional theory known the theory of unconstitutional constitutional amendment, meaning that the Constitutional Court has a right to strike down a law or referendum, even a referendum which is a constitutional referendum, amendment of the Constitution, if it infringes upon some constitutional provisions. In other words, that a constitution may be unconstitutional. This is nowhere written in our Constitution. There is no prerogative of this type in our constitutional system. And since the Constitutional Court proclaimed its power to do so, this is the most notable example of the case law related to referendum in general. We will see the consequences in the following years if they appear in practice. And before giving my final remarks, let me just mention that in the previous months we have had also two notable referendums on so-called outsourcing of some technical services in state and public bodies, and the referendum on the commercial use of state roads in Croatia. Two cases which were both, let's say, stopped by the Constitutional Court rulings. So these referendums were not held because they were proclaimed unconstitutional by the Constitutional Court. If you dig deeply into these cases, you will see that some basic fundamental constitutional issues also rise in both of these two cases. The first one, for instance, the right to work versus governmental budgetary powers and powers related to economic policy of the state. The Constitutional Court gave precedence to the latter. And in the second case, the issue of public goods, in this case highways and roads in public ownership in Croatia versus freedom of market and enterprise. In the second case, also the latter category prevailed. What remains for the future? Of course, the complete revision of the referendum system, not only in constitution but also on legislative level, mainly focusing, I would stress, to 2 points. The first one is the better regulation of judicial reviews from the those issues that may be decided on a referendum in general. Thank you very much.